Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
All right, welcome to the FloridaDefense.com podcast. We are speaking to Tampa Firearms defense lawyer Mike Kinney. Mike, how are you today?
I'm doing great. How are you?
Doing well. Let's kind of get into a concealed firearm. It's kind of a big thing going on, and
well, that's firearms law in the state of Florida. I would say I don't want to say simple. I just want to say there isn't a lot of restrictions on ownership of a firearm. There's nothing really illegal about owning a firearm. You don't need a special permit to own one. You don't need a special permit to keep one in your house. Obviously, you have to keep one safely in your home, especially if there are children in your home. But there's nothing to where there's like a registry of people in Florida, or you have to apply to have permission like you might in some other states. The unique thing about firearms is it comes up in two different areas where it becomes a crime, right? If it's used in a criminal manner, right, you're shooting at somebody or committing a robbery, that brings you into a whole different scenario. That brings you into Florida's 10-20 life law, where possession of a firearm gives you a minimum mandatory of at least 10 years in prison if you're using it to commit an enumerated felony. But what you normally see in firearms cases, which is more common, is just the possession of it in and of itself. A person who possesses a firearm, but they have it concealed on their person or so near their person that it's considered on their person, that's carrying it concealed. And that's illegal in the state of Florida unless you have a specific permit that allows you to carry a concealed firearm. The alternative to that is you also can't just go walking around with a gun in your hand in the state of Florida. For instance, you can't walk into a store and have a gun sitting on your hip in an open holster, open carry. That is illegal. Walking around with a firearm in your hand is called an improper exhibition of a firearm, potentially, depending upon how it's being held or displayed. So it's really, you can't have it open and you can't have it concealed unless you have a license. So some people find themselves getting themselves into trouble. The best way to go is anybody who's ever going to possess a firearm, it probably makes a lot of sense to get the concealed weapons permit. They require you to take certain firearm safety courses, go through specific background checks. You obviously can't be a convicted felon. And that would allow you to carry a firearm in the places that you're allowed to carry it. There are certain places that you may not, like an airport, a bar, obvious places of nuisance. These are things that kind of make sense. The unique thing about the carry and conceal firearm statute is there's been a lot of cases addressing the two things that the state needs to prove to convict someone of carrying a concealed firearm. For instance, I had a trial just last week where a person was charged with carrying a concealed firearm, and that case was unique. That case, my client was pulled over subject to a complaint about firearms being used in a potential crime, and officers came out, and officers, when they do a stop in a situation where they believe a person in the vehicle may be armed, they do what's called a felony traffic stop. Felony traffic stop is when the officers come out with their guns already drawn. It's not like they turn their lights on and walk up to your window nicely and say, "Hey, can I talk to you?" They're concerned. They want to make sure they get home to the family, so they come out with their guns drawn. And they have all their lights on. They have special takedown lights. They have special spotlights because they want to see every aspect of the car. And at the trial, the testimony was the officer saw my client, who was seated in the back of a vehicle, holding a firearm essentially over his shoulder, kind of turn a little bit and throw the firearm over his shoulder into the back compartment of the vehicle. And it went basically from the passenger compartment of the car into the trunk. Officer said they ordered my client out of the car. They secured him, spoke with him, and my client maybe made some incriminating statements according to the officers, and then they searched the trunk of the car. And the officers searched the trunk of the car and find a gun sitting right there in the open compartment. Seeing this, the officers charged my client with carrying a concealed firearm. So that instantly, when I was hired for that case, a couple of questions went through my mind. Question one was, I'm not really sure how concealed that is. And question two is, if it is concealed, is that firearm considered carried? Is that on the person or so near to the person that it's readily accessible and considered on the person? And that is the two things that the prosecutor has to establish. The testimony at the trial surprisingly, no one knew how the firearm got from the front, or not the front, but the passenger compartment of the vehicle into the trunk. We all probably can surmise how it happened if it happened that way, right? These back seats have these full back seats that you can, reach right into the trunk if you wanted to. And for whatever reason, and it kind of surprised me in the middle of trial, but there's really no photographs of what these seats look like, and it was just testimony of my client dropping something over his shoulders. There was no measurements that were performed when the firearm was seized, no pictures that were taken. So all you have was the officer's word saying the guy dropped something over his shoulder, and then I found it in the trunk. When I cross-examined them, the officers could not clearly tell us where it was found in the trunk. So I told the judge that raises some issues. The issue that it raises is if they were going to consider that a concealed firearm, how could they show that my client could easily reach that? I don't even know how it got back there. I don't know if it was a big hole or a little hole. I don't know if he could fit his body in there. And in the end, the court agreed. Although the court, I think, reluctantly agreed. I think the court was concerned about the facts in that case. The court had to abide by the law, and the law, as it is, the state wasn't able to prove that my client could have accessed that firearm because there was no testimony that would show that. So the bottom line is, I think my client especially walked into that case thinking things weren't going to be particularly great for him. Don't ever do your own lawyering. Don't ever do your own thinking. I mean, you can have some common sense and kind of see a picture on the wall and realize, oh, this isn't very good. But don't ever wave the white flag before you hire a lawyer. Hire a lawyer. Have somebody do the work for you. Have somebody do the research, because amazing things can happen when somebody sits down and dedicates himself to defending you. And in that set of circumstances, things worked out very well, obviously, for my client.
Anything else on firearms?
No.
All right. You've been listening to FloridaDefense.com podcast with the Bauer, Kreider, and Perry law firm, and we've been speaking to Tampa firearms defense attorney Mike Kinney.
Thank you for listening to the FloridaDefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit FloridaDefense.com today.